Hello, my name is Sasha Struthers. I'm an employment attorney here in Los Angeles. Today I'm doing a video on harassment, discrimination, and retaliation in the employment context. I was gonna film this outside because it's nice out today, and there was a very obnoxious crow. And if you can see the rapid change in lighting, also nature. And there's the horse neighing from next door. So we'll see how this video goes, but I was trying to mix it up for everybody, and outside would not cooperate. But anywho, moving on. In today's video, I'm going to talk about the different kinds of harassment and how employees typically report harassment and deal with it. So to begin, harassment comes in two forms. So there's sexual harassment and non-sexual harassment. Sexual harassment can be quid pro quo, which is this for that in Latin. So usually comes in the form of an employer, someone in power, demands some sort of sexual favor in advance or in exchange for the employer giving the employee some sort of benefit, usually a raise, a bonus, a promotion, something like that. Or it can be that the work environment becomes so hostile based on sexually aggressive conduct. The quid pro quo is specific to sexual harassment. Hostile work environment is typically a non-sexual harassment, non-sexual nature harassment, which is the employee is suffering from a work environment that's so negative and hostile, makes it very difficult, if not impossible, for an employee to do their job. Now, this typically, a non-hostile harassment usually comes down to the harassing person, which is the person in power. The employer, manager, supervisor is harassing this employee based on either them being in a protected class, which California has about 12 of them. The most common ones being race, national origin, religion, sex, sexual orientation, age. There's a few more, but those are the main ones. Or because the employee is partaking in some sort of protected activity, which is usually the employee complaining about the employer violating employment laws, actually going to government agency or going to HR and complaining. There's different kinds of activities. That's the most common one, is complaining about employment law violations. So the employee gets harassed. Discrimination is when the employee is treated either less favorably because the employee is in a protected class, or that the employer's policies disproportionately affect a certain person or group of persons in the workplace based on them being in a protected group. So that's discrimination, is the treatment of the employee. Typically that I see this being employers will punish some employees to the exclusion of other employees based on that employee being in a protected class. And then retaliation is usually in the form of the employee getting demoted, disciplined, or terminated for partaking in a protected activity. This is usually the basis or in conjunction with a wrongful termination and a whistleblower cause of action. If the employee, went to a government agency or went to HR and complained about employment law violations, and then the employer retaliated against the employee for doing so. So those are the three main, what I kind of call subjective claims: harassment, discrimination, retaliation. Those are three big no-nos in California under the Fair Employment and Housing Act, FEHA. And those are typical bases for lawsuits in California, especially in Los Angeles, just given the volume of jobs that exist here. What employees can do, or what employees typically do, is if they believe that they're being discriminated against, harassed, or being retaliated against, then they report to either the employer, if it's, if the employer is not the harasser but above the harasser, the person partaking in the inappropriate conduct, or they can go to HR if there's a different, sector in the business or area, or different maybe HR company. They can go to HR. They can go to a government employment agency, or typically an employee will go to an attorney. And so those are the avenues. They go to an employment attorney who knows this area of law and can consult with them on if the conduct is in fact actually a basis for filing a complaint or doing something like that. But if you're going to file a complaint for one of these things, you have to engage with the Department of Fair Employment and Housing, and you have to go through a process with them formally before anything can go forward in a lawsuit. So if you have an employment-related issue, either you're an employer or an employee dealing with harassment, discrimination, or retaliation, I give free consultations. So please reach out and we can schedule one and go over your particular situation. And I wish everybody the best of luck and a happy work environment, or at least a stable one. Thank you.